Thank you very much, Mr. Chair and members. AB 2323 prevents the insurance commissioner and key appointed Department of Insurance staff from conducting a covered communication unless they disclose and publish the communication on the department website. The public interest principles of fundamental fairness and due process of law require that the commissioner and department staff conduct their affairs in an open, objective, and impartial manner, free of undue influence and the abuse of power and authority. AB 2323 provides that the insurance commissioner and key commissioner appointees shall not make a covered communication unless they disclose and make public that communication by reporting and publishing such communications quarterly on the department's internet website. Specifically, the department shall adopt a standard disclosure form for reporting covered communications that shall include the date, time, and location of the communication, the identity of the person or persons initiating and the person or persons receiving the communication, the identity of the person on whose behalf the communication was made, the identity of all persons present during the communication, and the topic of communication. In essence, a calendar entry. To be effective and for a healthy economy, California's regulation of the business of insurance requires public awareness, understanding, support, participation, and confidence in the commissioner, department staff, and their practices and procedures. Accordingly, this bill is necessary to preserve the public's welfare, the integrity of the regulatory process, and to maintain the public's trust in the commissioner and key department appointees. With me today, as a witness, I have Carmen Balber of Consumer Watchdog.
Good morning, members. Thanks for having me. My name's Carmen Balber. I'm the Executive Director of Consumer Watchdog, and we're here in support of AB 2323. California's insurance commissioner is the most powerful consumer regulator in any state in the nation. He makes decisions that daily affect the pocketbooks of every California individual and business owner as he oversees the $300 billion plus insurance industry in California. And with that power and authority comes the obligation for integrity and transparency. And it's been made very clear by recent events that critical decisions at CDI are being made behind closed doors after the commissioner and the commissioner's top deputies meet with interested parties in those decisions. In 2019, an investigation uncovered that the insurance commissioner had taken campaign contributions from individuals linked to insurance companies with matters before the agency. One of those companies was facing actions by the department for overcharging businesses for their workers' compensation coverage. The commissioner then intervened in those proceedings and reversed decisions by administrative law judges. Commissioner Latta later admitted that he had met with the president of the company to discuss those decisions and also the status of a merger the company was seeking. Later, through a Public Records Act request and then a lawsuit that Consumer Watchdog was required to file because the commissioner and the department were not forthcoming with records of these meetings and communications, we discovered that other officials at the CDI had undisclosed conversations with representatives of this insurance company, including lobbyists who had been promised a $2 million success fee for winning the merger the company was seeking. None of these private meetings would have ever come to light if the campaign contributions hadn't first drawn media attention. But the public has the right to know that these communications are happening. Who is influencing the commissioner proactively instead of having to wait for a scandal that spurs media or other investigation? AB 2323 provides that transparency by requiring the commissioner and only the highest level appointees to record and report their communications with interested parties. And this additional level of transparency is crucial to restore the public's confidence in the operations and independence of the Department of Insurance. So as an organization that frequently communicates with the CDI at the highest levels, we welcome this kind of sunshine. We hope that the commissioner and the insurance industry would welcome it too. We urge your support for AB 2323.
Thank you, Ms. Balber. Are there other persons wishing to speak in support of this bill? Are there persons here who wish to speak against the bill? I see one person coming to the fore. Go ahead, sir.
Thank you. Thank you. Good morning, Mr. Chair and members. Saren Taylor on behalf of the Personal Insurance Federation of California. Thank you for the opportunity to comment on AB 2323. Hopefully you've seen our letter and know that we are opposed to the bill for several reasons. First, not every bill that claims to be about transparency actually is. We think AB 2323 imposes new complexity on CDI operations that will waste time and resources, but it does not serve the public interest or increase transparency. As noted in the committee analysis, there are numerous transparency laws that currently apply to CDI, including the Administrative Procedures Act, or APA, governing ex parte communications, and the Public Resources Act, PRA, which provides for access to all public records and information. CDI has also adopted an additional set of rules that go beyond the APA, so it is already more protective than other state entities are even required to be. However, the major concern we have with this bill is not that it's unnecessary or wasteful. It's that the threat of civil fines against CDI staff for noncompliance, with the potential award of attorney's fees and other costs, will disrupt CDI operations and chill the exercise of First Amendment rights by disincentivizing the commissioner and CDI appointees from engaging in conversations permitted under California law with the entities subject to regulation by CDI. Insurers already find it challenging to work with CDI bureaucracy, and adding laws that threaten the staff and interrupt the free flow of communication between stakeholders and the elected insurance commissioner at a time when really we all need greater communication and collaboration to address the challenges in the insurance market is harmful to all Californians. So in summary, we think this bill won't increase transparency, but it will impede CDI operations, create unnecessary barriers to communication for any civic, environmental, neighborhood, business, labor, trade, or similar organization who needs to work on a matter before CDI. And we respectfully ask for your no vote. Thank you.
Thank you, Mr. Taylor. Other comments in opposition to the bill?
Good morning, Mr. Daly, members. Matt Powers with the Association of California Life and Health Insurance Companies. I'd just like to align myself with the comments of my colleague, Mr. Taylor. We continue to have strong concerns about the workability of the reporting that this measure requires. The core mission of the department and its employees is the regulation of the insurance marketplace, and the department's resources are finite. Adding additional daily and weekly administrative burdens in service of a poorly defined problem is a distraction from the important work of regulating California's insurance marketplace. Furthermore, the civil penalties of up to $7,500 plus legal fees this proposal subjects the department's employees to is completely disproportionate to the harm an infraction would cause. For comparison, non-filing of FPPC campaign reports are subject to $10 daily fines. Simply put, the civil penalty provision will instill a culture of fear and cut off communication with senior departmental staff, which is integral to the well-functioning of a marketplace and a regulator. Thank you very much.
Thank you, Mr. Powers. Other comments in opposition?
Mr. Chair and members, Mandy Lee on behalf of the American Property Casualty Insurers, in respectful opposition, aligning ourselves with the previous speakers.
Go ahead.
Good morning. Sherry McHugh, representing the Pacific Association of Domestic Insurance Companies, in opposition to the bill. Thank you.
Thank you. Any other comments in opposition to the bill? Committee members, do you have any questions for the author on the bill? Mr. Vopel.
A minor question and then a comment, if I may.
Go ahead.
How long ago was that campaign contribution that sparked all this off?
2019.
And that is the current insurance commissioner, correct? Okay. My comment is, when you cross insurance regulation with politics, there's going to be some problems there. Always has been. Always will be. I am in opposition, and all the points made by the others in opposition are absolutely spot on. Looking at this from an insurance professional's viewpoint, many times the insurance commissioner will reach out to a broker, a company, a brokerage firm, even admitted or non-admitted companies with inquiries. Hey, what are you doing, basically? Now, if it's an innocent inquiry on a company's performance or procedures, many times the insurance commissioner is satisfied. Now, what will happen here, and the chilling effect they're talking about, is I'm broker A, insurance commissioner questions some of my practices. Well, with a disclosure within 7 days and civil fines, now it's not just an inquiry. It's not just trying to get information on the regulator's part. Now it's an inquisition, and it can be used by my competitors. It can be used many different ways because now you're on record. So that's my comment there, sir.
Good.
Yeah, if I may, Mr. Chair, and I respect Mr. Vopel's concerns and position, I think that what got your attention, and again, I don't believe that this is what colored your entire viewpoint of what you've just said, but what you led with was, when did the contributions occur? And the contributions aren't actually the point of this bill. The contributions really have no impact on this bill. The contributions are actually just a minor part of a story. It was what drew people to ask for more information about communications. Without that, we wouldn't have had the Public Records Act request to understand, yes, contributions happened, but there was a significant overruling of administrative law judges dealing with that donor. So what was important wasn't the contribution. What is important, what are the meetings that occurred that led to overturning staff? These are people who are dedicated professionals in their careers, regulating a $300 billion insurance market, the fourth largest insurance market in the world. What were the communications? That's what this bill gets to. It's not about the politics of campaign contributions. We just don't know what those communications are. So if you want to understand, why would an insurance company that overcharged small businesses in California, why would they be let off the hook when all of the staff regulators say that they should be held accountable? You need to know what communications occurred.
All right. Any other questions or comments for the author?
Chair.
Go ahead, Mr. Mays.
I think that the author's purpose in this is sincere in trying to right something that he sees as a wrong. I've just historically not been supportive, even back on my time as a city council member, when dealing with ex parte communications as it applied to planning commissioners. The First Amendment of the U.S. Constitution is very, very clear, and one of the most fundamental parts of our government is the ability to be able to petition elected representatives. When I have a constituent that comes and meets with me, that conversation that I have with that constituent is private between me and them. And then we don't make notes, we don't take notes, and we don't publicize those conversations. And I think it's appropriate for elected officials to be able to have conversations with those that are petitioning them. And I think the rules that we have in place in regards to the Public Records Act and other things is more than enough. And I think this just goes too far. So I won't be supporting this today.
Thank you, Mr. Mays. Any other questions or comments? This bill is on the agenda today as a courtesy to the author, who we all respect, but there is no recommendation that goes along with the analysis. The analysis lays out all the issues and the pros and the cons. So did I hear a motion? I don't think we had one motion. One maker of a motion. Is there a second? Well, we don't have a full committee yet, Mr. Levine. There may be others who arrive. Mr. Cooley is out with an illness, and there's a replacement for him, Ms. Garcia. So we will proceed without voting on this bill yet.
Well, thank you, Mr. Chair, and thank you, members, for hearing this out. This bill is not to chill communication at all. It does not stop communication one bit. It doesn't say that you can't contact the regulator and staff. So it does not discourage that at all. And of course, if there are issues that have legal proceedings, that is covered differently under the law. So it doesn't reveal anything that wouldn't otherwise be revealed in certain situations, Mr. Mays. So I hear your concern about that as well, because I have in the past had concerns about ex parte communications and whether or not people can get the information they need to make good decisions. And we want to encourage that to occur. So as this bill kind of sits in your mind and you have a chance to digest it and think about this conversation, please consider making a second when the bill comes up. Yet again, I want to say thank you, Dr. Wood, by the way, for that motion. I'm grateful for that. And so please, with your consideration, I respectfully ask for an aye vote.